all rise. The appeal in a claim on the application of Philpot and condition for police.
Yes, Mr. Gormley.
May it please your lordship, your ladieships, I appear for the appellant, Mr. Philpot, who sits to my left. Mr. Morley, the counsel, appears for the Commissioner of the Police of the Metropolis, both counsel having appeared below. The court, I hope, has some skeleton arguments from each of the parties, and 3 bundles, a core bundle, a supplementary bundle, and an authorities bundle.
Yes.
I'm grateful. This is an appeal in relation to a judicial review. The fundamental point in issue being to what extent and in what circumstances a chief officer may impose conditions on the private life of police officers within their ranks, and the context within which the case arises is that the appellant is a serving police officer with the Metropolitan Police under a misconduct investigation in respect of alleged misbehaviour and misconduct towards his wife, whose criminal investigation concluded with no further action, and upon whom restrictions have been placed by the MPS, which include a restriction which prevents him from contacting his wife and terms by which he must abide if he is to seek contact with his children. And the rationale given for that restriction has been that she is a witness in prospective professional misconduct proceedings, and that he should not have contact with her because she bears that potential capacity. And the claim challenges the lawfulness of the imposition and maintenance of that restriction. And indeed, the issue may be framed as whether police forces have powers similar to, or perhaps greater than, the criminal courts have to impose conditions of bail. And this is in particular in relation to those officers that are party to misconduct investigations or proceedings, but not so limited to such cases. The discipline, witness, contact context is the basis of these facts, but the judgment that we appeal is not so limited, finding a general power to impose private life restrictions. This appeal is against the judgment of Mrs. Justice Lang, handed on the 19th of July 2022, reported at 2022 EWHC 1852 admin, and the case before her, there were 4 grounds initially. Ground 1 was that the imposition of the restriction was ultra vires regulation 11 of the police conduct regulations, that relates to suspension and restrictions. Ground 2 was that it was unlawful pursuant to Regulation 6 of the Police Regulations 2003. Ground 3 was that it was ultra vires Section 4.3 of the Police Reform and Social Responsibility Act of 2011. And finally, ground 4, unlawful under Article 8 ECHR, right to private and family life. And this appeal relates to 3 of those 4 grounds, the appellant having succeeded on ground 1, that the power was not within Regulation 11, lost on grounds 2 and 3, and achieved what might be described as a pyrrhic or partial or technical success only on ground 4. No relief was granted, and the respondent does not appeal ground 1, the Regulation 11 point, and indeed had never contended there was such a power in Regulation 11. They'd only argued that it hadn't mattered that they'd used the wrong provision. The facts of the case can be found at page 55 of the claim bundle. They're also accurately relayed in the judgment of Mrs. Justice Lang between paragraphs 10 to 31, that's the core bundle at page 65. Subject only to this, the final sentence in both of those descriptions of the facts describes that the case awaits a decision on whether there's a case to answer in the professional misconduct proceedings. That decision has now been made in respect of the appellant, and the respondent has decided there is a case to answer in professional misconduct, and so those proceedings are now awaited. for those that are watching, the facts might be briefly summarised as follows. The claimant, serving police officer, investigated for allegations of mistreatment of his wife that included assault, abusive behaviour. There was an arrest on an allegation of controlling and coercive behaviour and malicious communications. He has always denied all wrongdoing. The criminal investigation concluded with no further actions and no adverse findings. And while subject to those criminal allegations, bail conditions were placed upon him that had a particular limit of time. May I ask the court to turn to the supplementary bundle at page 32, please. To put the condition in its context. In the second box, we're looking here at the criminal investigation papers, and in the second box there's a reference to bail. I won't use the names, but it's not to contact directly or indirectly or via a third party or any social media the appellant's wife, and not to make arrangements for child contact with the named children, say through social services or responsible third party. Those were original bail conditions. And if then one turns forward, please, to page 34 in the same bundle, you can see from around the third short paragraph that bail started in September 2020. Senior police officer extended it until the 23rd of December 2020, and this document is an application to the court. If one looks at another paragraph further, two paragraphs forward, DC Nahar made an application as a constable to apply for a first extension of 9 months from the bail start date. So this was a 6-month bail extension application. And I seek to draw attention to what it says at the bottom of that page and the top of the next. The district judge said that they were not satisfied. Sufficient reasons had been provided to show a decision was unlikely to be made or the investigation completed within 3 months from the relevant period, because at this stage there are insufficient reasons given to the court indicating why the necessary information cannot be sought within the next 3 months. And then there's particularly if these offences relate to a serving police officer and have implications not only for his ability to have contact with his children, but also his likelihood. So here is the court being asked for a 6-month extension to take it to 9 months, and concerns over private and family life rights and interference with those placed a limit on the time and a lesser private life restriction, something the respondent contends the chief officer can and did do without the limit of time for a possible discipline case. And so those conditions were then reflected and later combined in reach within the discipline investigation, and for that we stay in the supplementary bundle that turn forward to page 48, please. This document with the green headings is a pro forma document that relates to Regulation 11 of the Police Conduct Regulations used within the Metropolitan Police. And within the bullet points towards the bottom of the page, there are 5 conditions: work within the confines of a police building under supervision, have no involvement in any matters concerning domestic matters or domestic violence. Then what we're calling restriction 3, centre of this case, to have no direct or indirect contact with the appellant's wife unless it is required by the family court. And then 2 more, to work in dispatch only communicating with officers and staff via the police radio, and no working in first contact. That refers to direct contact with the public. And we submit that restriction 3 is conspicuous and different in nature and kind to the others that relate to duty, relating as it does to private life. And if one looks over the page within this same document, within the explanatory notes of restricted duty, one can pick out in the 3rd paragraph, about 3 lines down, there's reference to the conduct regulations and reference to Regulation 11. And so it was that this restriction, as we know, was purportedly imposed subject to Regulation 11, which was that ground that was settled at first instance. The only further development in the restriction one finds at page 56 in this same supplementary bundle. This is one of the review documents. It was dated the 4th of June 2021. And again, towards the bottom of the page, there's an amendment to restriction 3. And it's amended to have no direct or indirect contact with appellant's wife unless it is required by the family court or for childcare matters, which are to be via a third party. And that is restriction 3 in its final form. That is challenged in this case and was maintained originally under Regulation 11, but survived the first instance judgment, the judge having found there was power to impose it under 2 other provisions that we will be considering. And so the restrictions we submit included perfectly lawful, unobjectionable restrictions on his duties and on his powers as a police officer. Indeed, that could have gone further to complete suspension, but they also included this restriction that prevents or restricts contact with his wife and the terms by which he must abide in order to make contact with his children. May I then turn to the grounds proper in their detail? The first ground under appeal is our ground 2, and regarding the judgment that is under appeal here within their skeleton argument, sought to distill the findings of the court below into separate determinations in respect of which each point in which enumerated points are made, which in my submission taken together demonstrate the judgment is in error. And we begin within the claim or the core bundle, within the judgment at paragraph 68. So that's page 77, please, of the core bundle. We'll be looking at the judgment of Mrs. Justice Lang that is under appeal.
Before we do that, Mr. Bulmer, can I just ask a couple of points? Firstly, in the recital of the facts, we are told that there are some family court proceedings going on. Do we know what orders have been applied for or made? For example, has Mrs. Philpot ever applied for a non-molestation order?
I understand not, my lord. Indeed, it's in terms of our submissions, in the latter part of the submissions, we set out all of the other mechanisms that are provided in the criminal civil law to protect the individual, bearing in mind that the rationale that's given in this case for the imposition of the restriction actually has nothing to do with protection of the appellant's wife. That isn't the issue in this case. What is submitted is that there's power to prevent the appellant seeing her because she was a potential at the time and now likely witness in discipline proceedings. But in answer to your lordship's question, there have been, I'll turn to my client to make sure, no applications for non-molestation orders or civil injunctions for the protection from harassment. Indeed, the family law proceedings are effectively settled and resolved now, in that the access to children, etc., is up and running, and there's nothing outstanding. But the short answer to your lordship's question is no such applications.
All right. Coming back then to police powers, what is the source of the power of a chief officer to prohibit an officer accused in disciplinary proceedings from contacting witnesses?
That power doesn't exist, my lord. The powers in relation to an officer under discipline in our submission are contained within Regulation 11 and relate to suspension and to duties. And the options there are to suspend, which removes the police powers altogether, or to pose lesser restrictions on duty, just of the type and kind that we've seen within this list, being removed from the evidential chain or from contact with the public. But extension beyond that to a prohibition of conduct in private life, there is none.
No, forgive me, that wasn't the question I asked. I'm looking at the power generally. You'll have seen, I'm sure, Mr. Morley's email in response to a question from my clerk. I simply didn't know whether such restrictions are commonly imposed under Mr. Morley's clients. They are. And before we get into private life, I'm wondering what is the source of the power of a chief officer or their representative to say to an officer who's been suspected of disciplinary offence, you must not contact witnesses.
At the risk of moving into anecdotal evidence, I did ask this question in response to the email of the professional discipline lead within the Federation, and it seems that the issue came to light to them in terms of examples of non-contact about which officers were concerned, namely family members, in about December 2020. But as we can see from this case, the purported power that was being used was Regulation 11. We know that because the restriction is within the Regulation 11 pro forma, and when that was challenged, the restrictions now purportedly are placed under the other two provisions, which we are due to consider within the context of this case. So the decisions that were purportedly being made, as far as I understand it, and certainly on the facts of this case, the power was thought to be derived from Regulation 11, but the respondent has conceded, both in the court below and not appealing ground one, that they were doing so under a power that didn't provide for such a...
Regulation 11 is a power to suspend from the office of constable, to suspend altogether, isn't it?
Yes, but embedded within it is the lesser alternatives to suspension, namely restrictions placed upon duty. Although it's not spelled out expressly, it comes within Regulation 11 as the alternative to suspension and the terms upon which officers are redeployed. And that was the provision that was purportedly being used in respect of conditions that appeared to go beyond the duties of a constable, which we say they could not. But there is, in fact, effectively a standing prohibition on any adverse contact or interference with the misconduct proceedings in any event under the standards of professional behaviour. If I can ask you, my Lord, to look at the supplementary bundle at page 156. We'll find ourselves at Schedule 2 of the Police Conduct Regulations 2020.
Yes.
So these are the standards of professional behaviour. Effectively, the offence is the wrong word, but it helps to understand. These are the matters which an officer can find themselves in breach of, and the bedrock for any allegations of discipline. And within the standards of professional behaviour that must be upheld, one can see that some of them apply. Some of them apply on or off duty without any doubt. Honesty and integrity. Police officers are honest, act with integrity, and do not compromise or abuse their position. And looking to the next page, the penultimate standard, effectively a catch-all, that of discreditable conduct. Police officers behave in a manner which does not discredit the police service or undermine public confidence in it, whether on or off duty. And so, in respect of contacting witnesses, in respect of any contact that is adverse, that is likely to interfere with the discipline proceedings, in respect of any contact that is in any way perverting or seeks to influence a witness or compromise misconduct proceedings, there is already a prohibition on that, in that it would be behaviour that lacked integrity or was dishonest, and certainly that would bring discredit upon the police service. So there's no need for a particular order or a restriction to be placed on the officer not to interfere with witnesses. That is embedded within the standards of professional behaviour. It's already prohibited, and if an officer did do that, and I know of examples recently, I was involved in a case where this occurred, then further allegations of breach of those standards would be brought and joined up in the proceedings.
All right, so this, I should have asked really first, is there any objection to our taking into account the contents of Mr. Morley's email, and should it be put into the form of a witness statement, or are you happy to take it as is? I don't challenge the accuracy of it. What we don't know is the purported power that was used in those cases. We don't know from when they relate. But what I would submit is that the fact that the chief officer has been doing this to an extent doesn't make it lawful. We can see that the respondent can make a plea for the need for or the good use to which they might put such a power, but we submit that the power does not exist, and on examination of the precise provisions that we're considering, it's demonstrable that it doesn't exist. Subject to the observation I've just made, that there's no need for such directions because there's a standing prohibition on anything that would bring discredit, interfere, or could be said to lack integrity. One can think of all sorts of examples of an allegation of misconduct which has absolutely nothing to do with private life. Suppose, I don't know, a police officer is accused of accepting a bribe from a motorist not to report him or her for a traffic offence. A direction by the chief officer that pending disciplinary proceedings, the officer must not contact the motorist. The power to do that, you say, is derived from the duty of the officer to act with integrity, Schedule 2, and the chief officer's power to enforce that. Would that be the source of the power?
No, my lord, I submit there is no power to do that at all. That there is already a prohibition against the officer on doing anything that would be a breach. An officer might be advised that it would be unwise, or advise you not to do this because it might be seen in the wrong way or risk compromise to the proceedings. But in terms of the enforcement, yes. If there were contact made between a police officer and a member of the public off duty that compromised discipline proceedings, and the officer ought to have known that perhaps, then they would be susceptible to discipline charges, and the enforcement of their wrongdoing could be provided through the discipline regulations and the breaches of the standards. But the point at which the chief officer seeks to instruct or direct or order the officer that you may not have contact with another human being even in your private life. That is the bit that is missing. That
No,
there's no
please,
power.
can we just leave private life out for the moment? I'm trying to find the source of the general power. Mr. Morley tells us that these restrictions have been imposed, either met, in hundreds of cases. Are you saying that this case is a general challenge by the Federation to a no contact restriction imposed by chief officers in all circumstances, or only because it affects Mr. Philpot's private life?
We submit that there is no power to impose. I use the word private life, and I appreciate my lord's interested in a slightly narrower question, but it's another way of putting off duty. My friend's email says that we impose these restrictions on or off duty. We have no quarrel with a complete prohibition on any behaviour on duty, but we submit that the part of those directions that relates to off duty, or in my language, private life, but off duty might be better. For that part, there is no power, and each of those directions or orders are unlawful because there is no power. Now, in terms of the stranger motorist and the corruption, most oftentimes it's not going to matter to the officer because they will have no need, interest, or reason to contact the witness, and if they did, the inference that they were doing so improperly would be far stronger. And so it's in cases like the present one where it becomes a problem for the officer, even if what could be advice not to contact a witness an order not to contact a witness would have no lawful basis. Still not going to be the matter of complaint in most cases because it's not going to affect the officer, and they're not going to mind. But in our submission, there is no power to direct an officer regards their off-duty behaviour, but they are prevented and susceptible to allegations and discipline if they do something off-duty that would bring discredit or interfere or lack integrity.
I still don't understand where the general power comes from.
To impose an order that the general power to impose a restriction that applies off duty does not exist. That's
no. The general power to impose a restriction on contacting witnesses.
The power extends to regulation of duties and on-duty conduct within Regulation 11. There's nothing beyond that. There isn't a power to impose a quasi-bail condition. Something like a bail condition.
Well, then that must mean that all the 270 cases that Mr. Morley mentions, or at least most of them, the allegation, the restriction is ultra vires. I mean,
that part of it that is off duty, that's correct, yes, it is.
But contacting a witness to an allegation of misconduct against you does not seem to me to be part of the officer's duty.
No, they wouldn't, and they wouldn't be allowed to do it because they're prohibited from doing it by the standards of professional behaviour. They don't need to be told ordered by the officer, by the chief constable, not to contact witnesses, because within the standards of professional behaviour, they must act with integrity and not do anything that on or off duty that brings discredit upon the police service. So they are already prohibited from contacting witnesses in any and every case where the contact with a witness could be viewed as improper.
So you are saying that in respect of contacting witnesses, there is no need for a specific restriction because it's contained in Schedule 2 at page 156 to which you referred us. Is that it?
Yes, my lady. It's
Right. Can I go back then to the question my lord posed? Because like my lord, I'm in truth grappling to understand, and no doubt the fault is mine. But if you say that you have no quarrel with prohibitions, on-duty prohibitions, can I understand, please, what you say the source of that power is?
Regulation 11 of the police.
It's Regulation
Conduct
11.
Regulation.
Can we look at Regulation 11? And most of it is quoted in the judge's judgment, paragraph 41. I don't know whether there's any missing part, but she quotes it at paragraph 41. The appropriate authority may, subject to the provisions of the regulation, suspend the officer concerned from the office of constable and membership of the force. Right. Well, that wasn't purportedly done in this case. And then 4, the authority may not suspend a police officer unless the following conditions are satisfied. One of them is considering redeployment as an alternative to suspension. But surely suspension is all or nothing. This isn't the power to, there's no power to, under Regulation 11, to impose conditions on contacting witnesses, as the judge says in paragraph 42.
There is a requirement within 11.4 to consider temporary redeployment to alternative duties.
Yeah.
And that is the exercise that's being undertaken when decisions are made to prevent access to police indices, to not be in the evidential chain, to police in a way that doesn't involve first contact with witnesses, or to remain excluded from certain types of investigations. That's a way of redeploying the officer to alternative duties pending the discipline case. And so that's the sense in which restrictions apply. Restrictions are deploying an officer, redeploying the officer in a way that does not involve the full remit of what they might normally be allowed to do.
I entirely understand that in terms of restricting duties.
Yes.
Although chief officer isn't the employer of the constable, but let's say quasi-employer. Employers generally have the power to tell the employee what duty, whether you work in the front office, the back office, whether you work at nights, whether you work at days, what sort of, that's inherent. Suspension is different, Regulation 11. But I'm a bit, I don't know whether everybody accepts what the judge says at paragraph 42. I don't see how the power to prevent contact with witnesses can come from Regulation 11, and the judge says there's no express or implied power in the conduct regulations or the complaints regulations to restrict an officer's contact with witnesses.
Yes, and really the heart of this case is there is no such power. That's what restriction 3 is.
Yeah, but then it must apply generally. It's got nothing to do with private life.
Yes.
Either a chief officer does have power to restrict contact with witnesses, or he doesn't.
does have power to restrict contact on duty because he can decide how the officer is deployed. He does not have the power to prevent contact off duty. Does not need so to order because that is already prohibited within the standards of professional behaviour, which do apply off duty. So the difficulty in understanding where the power is understandable because it doesn't exist, which is at the heart of this case. The way in which the regulations are structured currently doesn't give rise to any problems because there's no chance of the inherent prohibition on such conduct trespassing into breaches of Article 8 or private life in an untoward way, because it's only contacts or behaviour that would bring discredit or lack integrity that are inherently prohibited.
So, does it come to this, that there is a general power, but there is the exception to that general power is if the restriction is a restriction on the officer's private life.
Yes, they can't cross the line into private life. It must be limited to something that relates to their duties.
All right, well, that probably does bring us to Regulation 6 and Ground 2.
I'm grateful, my Lord. So, Ground 2, may I begin with what we term Determination 1? That's found in the judgment at paragraph 68 or core bundle page 77, please. The learned judge here is finding that there are three separate powers. Paragraph 2 of Regulation 6, I'll turn to in a moment, of the 2003 regulations does permit the imposition of some further restrictions on private life of officers. The structure of paragraph 2 is convoluted and the language lacks clarity. However, I was assisted by seeing how the same paragraph had been drafted in earlier versions of the police regulations. I accept the defendant's interpretation of paragraph 2. It permits the local policing body or chief officer to impose 3 categories of restrictions on private life, but not just 2 as the claimant submitted. I'll turn to that. 3 categories are as follows. 1, those designed to secure the proper exercise of the functions of a constable. 2, those such as may be temporarily necessary under subparagraph A, which must be reported forthwith to the Secretary of State under paragraph 3. And 3, those such as may be approved by the Secretary of State after consultation with the Police Advisory Board for England and Wales under subparagraph B. So the core determination that I address initially is that there are 3 separate powers, one of which does not need to pass under Secretary of State superintendents, the other two of which do. And we say that's demonstrably an error for 9 reasons that are listed in headline form at paragraph 9 of the skeleton.
Right, can I just find that? Yes.
My Lord, Regulation 6 is found in the supplementary bundle at page 190. And the first point that that I submit is that the Secretary of State must scrutinise, must approve all Regulation 2 restrictions. Looking at Regulation 6 itself, I'll look in a little more detail at the underlying structure under a later point, but the court will see that under Regulation 6.1 there are general restrictions on private life that are imposed that are listed in Schedule 1. And then Regulation 6.2 provides that language that we shall grapple with, that no restrictions other than those designed to secure the proper exercise of functions of constable shall be imposed, etc., except A and B. That is the meaning of that is in central issue in this case. And then under 6.3, B restriction temporarily imposed under paragraph 2 shall be reported forthwith to the Secretary of State. The language within Regulation 6.3 does not refer to restrictions temporarily imposed under 2A, but rather 2. And in the present case, the restriction imposed is temporary. The restriction imposed is imposed under subsection 2. And therefore, by subsection 3, it must be reported forthwith to the Secretary of State. Even if the current restriction were to support the functions of a constable, which is a point in issue, it's still temporary, it's still under 2 and therefore caught by 3, and it cannot be in our submission that it was intended that the Secretary of State be notified of quasi-bail conditions in individual cases. And it would also follow from the finding in the judgment that only one of the 3 types of restrictions that are found within Regulation 2 can bypass the Secretary of State's scrutiny, and those are the ones that, in my submission, would be really in the principal category, ones that may be permanent. And I submit that it's doubtful Parliament intended such an apparently perverse result, that the judgment in the court below means that the Secretary of State would have to receive report of temporarily necessary restrictions, but not permanent ones imposed by chief officers, even those imposed against all officers, which in my submission does not make sense. Conversely, on the appellant's construction, it makes in our submission perfect sense that all Regulation 2 restrictions should pass by the scrutiny of the Secretary of State, because there is effectively one exception that must meet one of the 2 conditions, and they apply to all members of the police service. The first point is the absence of 2A, reference in subsection 3, means that that shows that all restrictions must pass by the Secretary of State, which is a clue that the restriction imposed in this case is unlawful. The second point made is in relation to the case of Allard at paragraph 13 of the skeleton argument. The basic facts of the Allard case: it was a claim by officers to recover overtime pay in respect of time they had spent dealing with covert human intelligence sources or informants that they were handling outside their hours of duty. And this was an authority that wasn't raised by the parties in the court below, but rather by the learned judge, and is cited in the learned judge's judgment at paragraph 61 of the judgment. That's at page 76 of the bundle, and I'm content that the court considers this authority on the basis of that part of it that's faithfully reproduced in the judgment. It's the part that matters.
Yes. Which paragraph?
Paragraph 61, that's at the top of page 67. So the quote from Allard: "Police officers are not employees, but office holders whose terms and conditions are prescribed by statute. Their deployment and hours of duty are a matter ultimately for the chief constable to determine. But their terms of conditions of service are set out in determinations made by the Home Secretary pursuant to regulations made under Section 50 of the Police Act 1996. This, we submit, is about a division of competencies, or where the line is drawn between matters that are for the chief officer and those for the Secretary of State, recognising that deployment and hours of duty are for the chief, but terms of conditions are for the Home Secretary under Section 50 regulations. And in my submission, private restrictions that touch upon private life are conditions of service, not a deployment issue. Indeed, that appears to be recognised within Mrs. Justice Lang's judgment, or also at the next page, at paragraph 66 of the judgment, the first paragraph of the learned judge's conclusions. Paragraph 66 reads: "Regulation 6, read together with Schedule 1, sets out the general restrictions on the private lives of police officers, which form part of their terms and conditions of service, of universal application to all police officers or classes." So, in my submission, we agree that Regulation 6 is a terms and conditions of service matter. These police regulations 2003 are made under Section 50 of the Police Act 1996, and as such, the Secretary of State retaining control and the decision-making over such things fits with that dividing line between the responsibilities. It's a conditions of service issue under Section 50 made regulations, thus a matter for the Secretary of State is our second point. The third point is to construe a separate power within the first part of Regulation 6.2 that applies to chief officers is inconsistent with the general scheme of Regulation 6.1. It's dealt with at paragraph 15 of the skeleton argument. May I ask the court please to turn back to Regulation 6. That again is in the supplementary bundle at page 190, this time looking at its fuller structure and Schedule 1. I've already read through Regulation 6 itself. Regulation 6.1, as I've mentioned, imposes restrictions on the private life that are contained within Schedule 1, deems them to apply to all members of a police force. And over the page within that bundle, actually, can I just point out also before I move on that the title of this section and schedule you can see reproduced at the bottom of the print. Restrictions on private life of members is the topic that this deals with. And over at page 191, Schedule 1, looking at the bottom for the title of it, Schedule 1, Restrictions on the Private Life of Members of Police Forces. So these are the restrictions that are incorporated under 6.1. Schedule 1, Paragraph 1, a member of a police force should at all times abstain from any activity likely to interfere with the impartial discharge of his duties or give rise to the impression among members of the public that it may so interfere, and shall in particular not take any active part in politics, not belong to any organisation specified or described in a determination by the Secretary of State. And I can tell the court that there are 2 such organisations so far that have been specified, namely Combat 18 and the National Front. Over the page to 192, paragraph 2, we're still within Schedule 1. A member of a police force shall not reside at a premises which are not for the time being approved by the chief officer. The next embedded restriction that officers accept when they attest. Page 193 is paragraph 3, is to do with lodgers. I won't read it all out, but effectively the consent of the chief officer is required if an officer wishes to receive a lodger in their house. And finally, page 194 is paragraph 4. A member of a police force shall not willfully refuse or neglect to discharge any lawful debt. And in my submission, the rationale for Regulation 6 is apparent from these items. It's not a random list. It's restrictions about protecting against corruption or becoming beholden or being impartial or having the appearance thereof. For example, a requirement that officers must pay their debts is important because that way they won't become beholden to a creditor subject to influence or corruptible on the basis of their debt. Taking lodgers, again, people that they have close association with the position to exert influence or suffer leaks. The politics embargo relates to impartiality, as do the prescribed organisations. But all of these restrictions in my submission go to policing powers and the exercise of policing powers and functions. And thus, if there are other ways that emerged in which private life conduct posed some general threat to impartiality or the exercise of police powers, then they might need extending. It might be something that needs to happen at short notice. Developments that haven't yet been seen, but they might relate to use of certain social media, to technology, to partaking in intrusive reality TV shows, if that were identified as something that gave particular concern and a lack of control and influence over the officer, or development of something that is not yet known or recognised. And so in my submission, the Regulation 6 sets down the general prohibitions for a reason, and Regulation 6.2 caters for the need, should it arise, for the extension of that general list, but subject, as I've already said, to the Secretary of State's superintendence. But the present point that I make is that the reading Regulation 6.1 and Schedule 1 in particular provides a general and universal prohibition at all times upon all officers from engaging activities that imperil that impartiality or the exercise of their powers in an improper way. Given that the purpose of the regulation in 6.1 is to provide a scheme whereby the limits are made express and explicit, in my submission it makes little sense in the statutory context to then confer a general unlimited discretion on the chief officer to impose whatever restrictions they thought necessary without reference to the Secretary of State in one part of Regulation 6.2, because Parliament cannot have intended to confer such on the officer, having been so prescriptive in Regulation 6.1 and so restrictive in terms of requiring things to be referred under Regulation 6.3. But Regulation 6.2 does, in my submission, make sense if it's read as conferring additional powers to extend for the proper functions of a constable as limited by the requirements of A and B to notify the Secretary of State as to.
Well, I suppose an officer has been involved in, let's say, has been drunk and disorderly in his local pub, off duty, and it's reported to the hierarchy, the chief officers, representatives, his managers, that he's been drunk and disorderly in this pub. He's not prosecuted. It's not even made the subject of disciplinary proceedings, but would the chief officer representative have the power to say to him, in view of this incident, you mustn't go to that pub, or you mustn't go to that pub after certain hours, or something of that kind?
Absolutely not. That would be a matter for the landlord and the officer, albeit the circumstances might be such, say if there were a complaint or a concern from the pub landlord that they didn't want to press the matter into discipline proceedings, but they were concerned about the behaviour. And if the circumstances were such that the officer attending in light of what had happened or people's views of it would bring discredit on the police service, then that's caught by the discreditable conduct standard under Schedule 2, because that does apply off duty. But there'd be no power to tell him not to engage in a possible apprehended breach of those standards, because one would ask where would that stop?
But that's because it's a restriction on private life.
That's because it would be a restriction on private life that does not relate to police powers or duties.
And
You could be advised not to do it. It might be advisable not to do it, and that might be evidence if it turned out that people found it discreditable when he arrived. But there would be an apprehended breach of the standards, or a possible breach of standards, and that's not something that can be ordered to be avoided by impacts upon private life. Again, the standing prohibition of that very widely drafted discreditable conduct standard means that there is no perverse result. Officers must behave at all times on and off duty.
You accept, I imagine, that police force can have a rule that you mustn't drink on duty. I don't know whether they do. Quite a lot of employers do. But
Yes. In fact, the drinking may not be a bad example of the application. Of course, an officer can be prohibited from drinking or doing anything on duty. But if an officer were to say to their sergeant, I intend to go and get extremely drunk tonight, and the sergeant was worried that if they do that, they're going to get into trouble or do something that they shouldn't, then there wouldn't be the power to order that officer not to go out to the pub to get drunk that night. If they did and they misbehaved, there was ample provision to deal with them for it.
yes, sorry.
My Lord, I was going through the points that we say establish that there aren't three powers within Regulation 6.2, but rather one that must meet one of two conditions. I'm at point D at paragraph 18 of the skeleton, and in fact, I'm going to wrap up some of the later points within this. The core submission here as to the meaning of Regulation 6.2, which I remind the courts at page 190 of the supplementary bundle, is that it is structured as one power, one exception to the prohibition on all restrictions that must meet one of two conditions. That's A and B. So it's one exception designed to secure the proper function of a constable that must meet one of the two conditions, A or B. And I'll largely deal with the semantic points that we make at paragraphs G to I now. We don't belittle them by reason of them being semantic, because we're dealing with the meaning of words here. But they all go to this core construction submission, that there is one securing proper functions exception that must meet one of two conditions, A or B. And we submit that if this were a sub-paragraph that sought to create three separate powers, then they would, first of all, more likely and logically be listed as A, B, C, rather than in the way they are. Within, as I mentioned before, within the judgment of Mrs. Justice Lang, she had summarised, the learned judge had summarised our submission as this Regulation 6.2 conferring two powers. That's one way of putting it, but better express what we intended to convey, and I think that means in the judgment is a single exception that must meet one of the two conditions rather than two powers. And we submit that the 6.2 would not be configured this way if three separate powers were in mind. I turn then to the next point in the same on the same issue, and that's the historical context, which we'd read in paragraph 68 of Mrs. Justice Lang's judgment at our core bundle 77. The learned judge had found assistance in finding the three powers from what she describes as previous iterations. This is a reference to what we find at page 245 of the supplementary bundle. A 1948 statutory instrument. This is an instrument that makes the police regulations 1948. This is making amendments to the police regulations of 1947, and the relevant part is over the page at page 246, which is the very first iteration that we can find. I say we can find. This was an inquiry that Mrs. Justice Lang invited the parties that had already conducted the exercise to redouble efforts upon, and Mr. Morley, my own friend, gets the credit for finding the oldest version, I think with the assistance of the librarian at the inn, to whom both of our thanks is repeated. 1948 inserts this into the 1947 regulations, paragraph 90A. The provisions of the second schedule to these regulations shall apply to all members of a police force, semicolon, and no restrictions other than those designed to secure the proper exercise of the functions of a constable shall be imposed by the police authority or the chief officer of police on the private life of members of a police force, except such as may temporarily be necessary, or such as may be approved by the Secretary of State after consultation with the Police Council. And any such restriction temporarily imposed shall be reported forthwith to the Secretary of State. Largely the same words in the same order, but without the altered punctuation and separation that we see in our version. In my submission, it's only the present iteration and its meaning that matters ultimately, and there may be a dangers if the provision has been materially changed by the way in which it's been set out, in knowing whether the changes were intended to change the law or to keep the law the same but to make it clearer. If it was to make it clear, it may be that those involved have not succeeded particularly well. But nevertheless, this is the first iteration that is known about. And the attention that the appellant wishes to draw to this is over the page again at the explanatory note at page 247. It was Regulation 7 that we just read, it inserted Regulation 90A. And the explanation for it is brief, but does tell us something. Regulation 7, amongst others, impose certain conditions as to conduct and restrict the imposition of restrictions on private life. And so in our submission, this explains that the purpose of Regulation 6 was intended to be prohibitive, to protect the private lives of officers, rather than to confer powers upon chief constables to interfere with them. And as such, a purposive interpretation of the regulation should be read in a way that is more restrictive of the imposition of any restrictions, because that's what it says in the explanatory note. And so, if anything, to the extent support can be drawn from this regulation from so long ago, we submit it's not intending and concentrated on bestowing powers, but rather restricting them, making a limited exception subject to conditions. And there was a single paragraph, then read as a whole, if anything, is equally consistent with an intention to ensure that everything reached the Secretary of State. The next point is back to Regulation 6.2a, and its construction is made at paragraph 20 of the skeleton, and asks a rhetorical question. If Regulation 6.2 created 3 separate powers, then that at 6.2a, the temporarily necessary ones, must be temporarily necessary for something other than securing the proper exercise of the functions of a constable. That was my learned friends and Mrs. Justice Lang's first category, securing the proper exercise of functions. Second, temporarily necessary, and third, for the Secretary of State. And the respondent has always been clear that they are saying that it means temporarily necessary for something other than the securing of the proper exercise of the functions of a constable, which begs the question, temporarily necessary for what? If of those 3, the second time are not for the exercise of constables, then what are they necessary for? It's surprising on that construction in our submission that a necessity test is introduced with no clue or indication given anywhere as to what this refers. And hence why we asked temporarily necessary for what. There's never been an answer suggested to this question before the skeleton argument in response to this appeal. There was no answer suggested at first instance or within that judgment. The respondent now says an example might be the preservation of public order, and I'll listen with care to what Mr. Morley says. I'm unsure what that means, whether to restrict officers' private lives to stop a riot by keeping them at home so they don't join in, or go in and be attacked in some giant civil unrest, or to keep them away from the public. I'm not sure what the example is said to convey, but there is no problem with this on the appellant's construction. On the appellant's construction, the meaning is clear, that the temporary necessity is to secure the proper exercise of the functions of a constable. They must be temporarily necessary for that. And that in turn fits with the entire purpose and structure of Regulation 6 and Schedule 1. The other points made within the skeleton argument, G to I, I've said, turn to the meaning of the words. In short, we submit they are all consistent with a single exception of the proper functions subject to one of the 2 conditions A and B. The only emphasis or thing I wish to add is just to emphasise our point on the word such. If one looks back at the Regulation 6.2 itself at Supplementary Bundle 190, within Regulation 6.2, both at A and B, the draftsman has included such as may be temporarily necessary or such as may be approved by the Secretary of State. And we submit that such must refer to those designed to secure the proper exercise of the functions of a constable. That's the only thing it can refer to. It's meaningless otherwise. So if that word means anything, it's identifying the functions, purpose, type of restriction. And my lord, my ladies, those are my submissions on the creation of 3 powers on determination 1. The next submission regards the finding that these may be, the first of these types that has been found might be applied to an individual officer. And this is turning back to the judgment at paragraph 69 and 70. That's page 77 of the claim bundle.
Yes.
69. Generally, the 2003 regulations set out terms and conditions applicable to all police officers or classes of police officers. In my view, any restrictions imposed pursuant to subparagraphs A or B of paragraph 2 are likely to be applicable to all police officers or classes of police officers, as they have to be reported and or approved by the Secretary of State. As both parties submitted, it seems highly unlikely that the regulations would require a temporary restriction on contacting witnesses imposed on an individual officer to be reported to or approved by the Secretary of State. We largely agree with that, save the word likely. We agree. 70. However, the description of restrictions designed to secure the proper exercise of the functions of constable does not expressly or impliedly exclude the possibility of restrictions being imposed upon an individual police officer. In my view, it confirms the broad powers the defendant has to direct and control police officers in the MPS currently set out in the PR SRA 2011. And then the paragraph continues. And so the finding that these may be applied to individual police officers is on 2 bases. The first, that it doesn't exclude it, and second, regulation, section 4.3 of the PR SRA, which is another ground I shall come to. The appellant submits, for the 5 reasons listed at paragraph 28 of the skeleton argument, that a number of factors combine to prefer the appellant's construction that regulation 6 is of general and not of individual application to individual officers. Paragraph 29 of the skeleton highlights the fact of the local policing body being mentioned and being mentioned first within regulation 6.2. The local policing body, of course, not being concerned with individual officers, something consistent with general restrictions intending to be imposed upon all members of a police service, which would again be consistent, we say, with regulation 6.1. What I've already submitted is the ever-present role for the Secretary of State. Second, the language that refers to members, the plural members, rather the imposition of a restriction on the private life of a member or members, again, something consistent with restrictions being placed upon the whole of the service, and in common with regulation 6.1, which denotes all members. That too is consistent with application to all members. And a point on which I would like to expand, if I may, and deal with some of the Article 8 authorities now to save need to repeat it later, is that at point C, that there is a perverse result on the appellant's construction, on the respondent's construction, and that found within the judgment of such a power because of the impact upon the fundamental rights of other people, of other family members, and such that a spouse or a child wishing to see their police officer, husband, wife, mother or father, surely cannot be frustrated in doing so by a chief constable's concerns over a possible discipline case including those in which there's not yet been a decision on whether there is a case to answer. In my submission, additionally, the absence of any procedural mechanism for the family affected to be heard or even informed of the trespass into their private lives it indicates that this cannot be Parliament's intention. And if I'd like just to turn to the Article 8 authorities to address two issues. The first is to demonstrate, for the benefit of the court, I hope it's at least a little helpful, one, the engagement of Article 8 in the context of police cases, and second, the significance of the absence of any procedural safeguards upon this construction for people affected, individuals affected by such a restriction. Article 8 itself, I know the court will be familiar with, it's found at this, in the supplementary bundle at 208, but given the no doubt familiarity, I don't ask it to be turned up. Equally included in the bundle is a case I needn't turn to in any detail, that of Burke's. It's merely an illustration of the application of Article 8 in the police context. The facts in that case were that the misconduct proceedings were a hindrance on the officer wishing to pursue a different vocation as a priest, and Article 8 was found to be engaged. Again, Mrs. Justice Lang, that's paragraphs 53 to 54. But I'd like to start, if I may.
Sorry, 53 to 54 of?
Paragraphs 53 to 54 Burke's. That's the Authorities Bundle 69. It is simply an illustration of the engagement of Article 8 in the police context. But I don't think to take any further than that. May I turn, though, to the case of Rukin? That's at page 74 of the Authorities Bundle. An authority that helps with the way in which Article 8 is incorporated into police regulations and give an example of the protection of private life in the workplace. Indeed, this is a reasonably stark example, effectively, as we'll see, confirming a right to lie to the deputy chief constable or senior officers if the lie is in protection of one's private life. The facts of Rukin, which can be found from paragraphs 18 to 20, shortly these, that there's a temporary chief inspector, a senior police officer that had a leadership role, who was brutally assaulted by the husband of a female police sergeant with whom he was conducting an intimate affair. And he lied to police colleagues and very senior colleagues about the circumstances that gave rise to his injuries, which lies slowly unravelled, and when confronted that he had lied, he acknowledged that and said he had misled his colleagues and lied to the deputy chief, the chief superintendent, and inspector. He had told them his injuries were caused in a cycling accident when in fact he had had a cycling accident, but the injuries were from the offended party in the private affair. But he said that he'd done that because he didn't want his children to know he was the victim of assault, his pride had been hurt, and he viewed the conversation as personal rather than professional, a view not shared by any of the senior officers who saw it as a professional conversation. And what had happened in that case, we find at paragraph 25, is that when the case went to discipline proceedings, the panel at first instance rejected the contention that the officer was entitled to lie by virtue of his Article 8 privacy right. On appeal to the Police Appeals Tribunal, the appeal was allowed, and this decision is the High Court upholding the Police Appeal Tribunal's conclusion that his Article 8 right entitled him to lie in protection of his privacy. And so it's at paragraph 68 or page 88 that I begin proper regarding the incorporation of Article 8 into the police framework. Article 8 ECHR, of course, has been incorporated into English law through the Human Rights Act and is specifically incorporated into the regulatory framework relating to the conduct of police. And then there's a footnote 3, I'm going to go to that now. Article 8 states as follows and repeats Article 8. Footnote 3 is 10 pages further forward at page 98 within the bundle. And it refers to paragraph 34, that's a reference to the Home Office guidance. And the specific reference in Home Office guidance to the necessity to balance restrictions on a police officer's private life with the officer's right to a private life. See Regulation 1.28 of the Home Office guidance. See also Regulation 6 of the Police Regulations 2003, to the effect that no restrictions other than those designed to secure the proper functions of a constable shall be imposed. I appreciate that there's a very brief mention of Regulation 6. The learned judge isn't directing his mind to the same question that we are, but it so happens that that extract reads in the way that we contend as a single exception. But the reference to the Home Office guidance, Regulation 1.28, is, at the risk of juggling bundles, it is a paragraph that is now repeated in the current regulations at our supplementary bundle, page 167. I'm going to go back to Rukin. I apologise for the juggling, but the Home Office guidance has been reissued, so I just need to establish that it's effectively the same. Page 167 of the supplementary bundle relating to off-duty conduct. Police officers have some restrictions on their private life. Some of these restrictions are set out in the Police Regulations 2003. These restrictions have to be balanced against the right to privacy in common law and right to a private life set out in Article 8 of the Human Rights Act 1998. Therefore, in considering whether a police officer has acted in a way which falls below these standards while off-duty, due regard should be given to that balance, and any action should be proportionate, taking account into all the circumstances. That's what's meant by the reference to incorporation of the Article 8 provisions within the police misconduct regime. And again, with apologies for the bundle juggling, if I can return to the Rukin judgment to identify those paragraphs that where the conclusions were drawn. Back to page 88, please, in the authorities bundle. At paragraph 71 of the judgment informs that it is clear that a person's sex life and their reputation both engage Article 8 considerations. It's also clear that a person's private life does not necessarily end when the individual enters the workplace.
Sorry, Mr. Gombright.
I beg your pardon.
The bundle juggling has
Yes,
failed.
I'm sorry.
Authorities page...
Authorities page 88. I do apologise. We're back in the Rukin judgment, having diverted through that footnote.
Yes, sorry. Paragraph
71, penultimate paragraph. It's clear that a person's sex life and reputation engage Article 8, and clear that it doesn't necessarily end when the individual enters the workplace. In Halford and United Kingdom, reference given, the European Court of Human Rights held that an applicant's right to privacy had been violated where the police service had intercepted private calls made on an office phone provided to the applicant, private use in her role as an assistant chief constable. Similarly, Copland in the UK, emails and websites within the work environment were held to attract the same protection. And this, my lord, my lady, is setting up what Rukin adds to the jurisprudence on private life, namely that there's such a thing as private life on duty. Because if we turn forward, please, to page 90, I'm only pausing here because one needs to know what paragraph 3.8 in that case was all about. So page 90 of the bundle, about 3 lines down, there's a reference to paragraph 3.8 of the panel's judgment. This was the issue. The panel do not consider that there is such a thing as private on-duty conduct, and that the officer should be operating in a professional manner in accordance with the Code of Ethics at all times, whether on or off duty. So they were saying no such thing as private life on duty. But the court disagrees, turning forward at page 95. paragraph 112. 95 contains the conclusions sections of the judgment. 112, in terms of the issues surrounding paragraph 3.8 we've just read, the panel's decision, it has to be said that it does seem to me to be clear there is such a thing as private on-duty conduct. It's the relevant part I wish to draw from that. And it's at the bottom of page 96 that the conclusion is reached that the officer in that case was entitled to lie to his supervisors in protection of his private life rights, including paragraph 120, including the acceptance that it was reasonable that if he'd asked one question truthfully, it would have led to others. Mr. Appellant in that case was saying, well, he could have said nothing. The court disagreed. And so that paragraph 120, I shan't read it out in full, but that's where the judgment finds that the Article 8 private life entitled in those circumstances, the lies to the superiors. And so there's an example of the operation of private life protections within the police context. And staying within the authorities bundle, the second point I seek to make is the problem for the respondent in there being no appeal mechanism against decisions such as the one in the present case. Page 3, please, of the authorities bundle. There's two authorities with which the court may be familiar, so I'll deal with them efficiently as I can. Page 3 is Glazer versus the UK, a decision of the European Court of Human Rights that highlights the problems and the significance of there being no mechanism, independent or otherwise, for affected officers and their families to seek to enforce their Article 8 rights when discipline leads or they can't see each other. Under Held Note 1, we learn something of the facts. The applicant there, father of 3 children, born to him and his former wife. The mother had claimed the applicant was sexually abusive towards the children, allegations that weren't substantiated, but orders in favour of the father were made for supervised access to be given to the children, which were thwarted in their application by the mother moving away. And over the page, at page 4 of the bundle at Held Note 6, there is this. The object of Article 8 is to protect the individual against arbitrary interference by public authorities. There may, however, be positive obligations inherent in an effective respect for family life, which may involve the adoption of measures designed to secure respect for family life, even in the sphere of relations between individuals. These can include both the provision of a regulatory framework of adjudicatory and enforcement machinery protecting individuals' rights, and the implementation, where appropriate, of specific steps. In both the negative and positive contexts, regard must be had to the fair balance which has to be struck between the competing interests of the individual and the community, including other connected third parties and the state's margins of appreciation. And so it's the adoption of measures designed to secure and the inherent obligations that I point to. In this case, staying on the same page at Held Note 11, the principal obstacle to the applicant enjoying contact with the children awarded under the court order of the 15th of July 93 was the opposition of the mother, who took the children from their home and disappeared, and her subsequent resistance to any contact being restored when they were located in Scotland. The question to be determined is whether there was an accessible and coherent mechanism provided for the enforcement of the appellant's contact rights with his children where the mother had refused to comply with the court order and changed residence from one jurisdiction in the United Kingdom to another. Both the English and Scottish courts had a range of measures available for the enforcement of their orders, including the power to obtain information from other government agencies to locate persons, the power to commit prison and sequester goods. And in the last line of that longer paragraph, the procedure was therefore demonstrated as simple and effective. So in that case, there were the mechanisms and the procedures available for the applicants to seek to enforce their rights. In the present case, short of judicial review, there is no appeal mechanism, independent or otherwise, for an officer or their family affected by such a restriction to be kept apart from each other, to seek to enforce their Article 8 rights, or have any say in the unilateral decision of the chief officer who's ordering them apart when they direct no contact. And this is a point that's reinforced by the case of W. That again is in the authorities bundle, this time at page 25. The facts in W, there's a reference in paragraph 8, where the context is an Article 8 procedural complaint in a case where there were serious marital and financial difficulties and a child was placed into voluntary care, we don't know, paragraph 8. And at 15, the authority, without any further reference to the applicant or his wife, considered and approved a proposal to place the child with long-term foster parents and to restrict the natural parents' access to him. So may I ask the court to look at page 36, please, at paragraph 54. Paragraph 54, identifying the complaint. Second line, the applicant complained about the procedures applied in reaching the decisions to restrict and then terminate his access to S, and about the remedies available to him in this connection, alleging violations of Articles 6 and 8, amongst others. And over the page, at page 37, I draw attention to paragraphs 59, 61 and 63 in this way. The first line of 61, uncontroversial perhaps, but important to our case. The mutual enjoyment by parent and child of each other's company constitutes a fundamental element of family life. At 61, the applicant did not assert the authority's decisions were not in accordance with the law or lacked a legitimate aim. The material before the court contains nothing to suggest the first of these requirements, as interpreted in the court's case law, was not satisfied. Neither is there any evidence that the measures taken were not designed to achieve a legitimate purpose, namely the protection of health or the rights and freedoms of others. Debate centred on the question whether the procedures followed had respected the applicant's family life or constituted an interference with the exercise of the right to respect for family life, which could not be justified as necessary in a democratic society. The applicant and the Commission took the view that the procedures applicable to the determination of issues relating to family life had to be such as to show respect for family life. In particular, according to the Commission, parents normally had a right to be heard and to be fully informed in this connection, although restrictions on these could in certain circumstances find justification under 8.2. The government, as its principal plea, did not accept that such procedural matters were relevant to Article 8, or that the rights to know or be heard were elements in the protection afforded thereby. I move to the next page, continuing the theme. Second paragraph. This reinforces Glazer. It is true that Article 8 contains no explicit procedural requirements, but this is not conclusive of the matter. The local authority's decision-making process clearly cannot be devoid of influence on the substance of the decision, notably by ensuring that it is based on the relevant considerations and is not one-sided, and hence neither is or appears to be arbitrary. And then moving forward to 63 finally, the relevant considerations to be weighed by a local authority in reaching decisions on children in its care must perforce include the views and interests of the natural parents. The decision-making process must, therefore, in the court's view, be such as to secure their views and interests are made known to and duly taken into account by the local authority, and that they are able to exercise in due time any remedies available to them. So a procedural duty to hear. In the present case, there is nothing provided within any of the regulations, within the police regulations, for representations or an appeal process against such a restriction in this essentially one-sided affair. No procedures provided for to fulfil the procedural obligation that would be engaged in cases like this. If this power exists and a chief constable can order families to be kept apart, because this is a principle of general application on the judgment as it stands, then there is an interference with their family lives that they have no recourse to. And no friend will say, well, we will listen, we do listen. But in my submission, that filter of discretion where a chief officer may or may not listen to the pleas of the family is insufficient, especially when the reason for their interference is something to do, nothing whatsoever to do with the family themselves, not to do with the spouse, the protection of the spouse, but rather with their discipline proceedings, which is why in the circumstance where the spouse, which he doesn't in this case, which they may in another, where the spouse or the child wishes to have contact that is unhindered or unconditioned to their parent, on the current construction, in the respondent's case, that family member would be at the whim of the chief constable, in respect of whom there's no appeal process for effective permission to continue and to see their family life. And that's an implication of the judgment that extends beyond the scope of the facts of the instant case. We also submit that, that within our skeleton argument that submissions on determination 1, if favoured by the court, assist, and skeleton paragraph 34, our point E, that the reasons that are given for the determination that there's an imposition to impose restrictions on individuals do not stand up to scrutiny. I apologise, within paragraph 34, there's a reference to paragraph 65 of the judgment. That should read 70. It's paragraph 70 at core bundle 77, in which I've already read, in which Mrs. Justice Lang says that private life restrictions can be imposed on individual officers for those two reasons, that it's not excluded, and because of section 4.3. I submit in respect of the first of those reasons that it is impliedly excluded for the reasons I've already given on determination 1, the role of the Secretary of State, the statutory regime properly understood, and the mention of the local policing authority. I also submit that if it is not clear, then it must be presumed there is no such power, given the implications of it. And I save my submissions on section 4.3 for ground 3. The next topic within ground 2 is the meaning of functions of a constable. If I'm wrong on what I've already submitted, nevertheless, in our submission, the determination that the present facts involve the exercise of the functions of a constable is wrong. I'm referring to the judgment at paragraph 75. So that's core bundle at page 79, please, for paragraph 75. It's clear the decision makers concluded the claimant represented a risk, both of harm to the complainant and to the integrity of the misconduct proceedings, which needed to be managed by imposing restriction 3. Restriction 3 was designed to ensure that the claimant complied with the standards of professional behaviour in Schedule 2 to the Police Conduct Regulations 2020 by acting with integrity and behaving in a manner which did not discredit the police service or undermine public confidence in it, whether on or off duty. In my view, compliance with these standards was an essential element of the claimant's proper exercise of his functions as a constable. Furthermore, the statutory discipline procedures in the Police Conduct Regulations 2020 and the Complaints Regulations are part of the police functions in which the claimant was participating. Restriction 3 was designed to ensure that the claimant exercised his functions properly within the disciplinary proceedings and did not jeopardise them by interfering with the complainant. So that the point here is that having found there is a power to impose private life restrictions to ensure the proper exercise of the functions of a constable under 6.2, the learned judge is finding that this situation where the officer is made subject to discipline proceedings is a case in which the exercise of his functions is engaged. So it's being found that being subject to an allegation is something that is the exercise of a police function. resubmit within the skeleton argument at paragraph 37. There are 4 reasons why that can't be right. The first 3 reasons really support our core argument. There's no private life restriction in Regulation 6. And the essence of this submission I make now on the precise point is that there is maybe a duty or responsibility not to pervert proceedings, but that's not exercising the function of a constable. The first point, though, is one that flows from our success on ground 1 in the court below. That there's no power to restrict a constable's private life provided for in Regulation 11. And we submit that if this power existed, that is where it would be. If not in Regulation 11, then within the police context, the police discipline regime. And having found there was no power in the conduct regulations, we submit that the learned judge was in error to divine a power for police conduct purposes elsewhere. If there were a bail condition type private life restriction power in furtherance of discipline investigation aims, then we submit it would be in the holistic, extensive, end-to-end discipline regulations and Home Office guidance. It's hundreds, which, although redacted from the bundle to meet the page limit, is hundreds, 277 pages long, with nowhere within it any hint of such a power for misconduct proceedings. We submit that Parliament has considered the issue of what restrictions or what measures should be taken regards officers subject to discipline proceedings, and have provided limits in their treatment of Regulation 11, and that the administrative court ought not to have been persuaded by the respondent's plea that as the power is not found there, that it must exist elsewhere, which in my submission is to reverse engineer the power and trespasses into judicial legislation rather than an accurate interpretation of what has been provided. Reference is made on this point to the principle of legality, and I submit that the defendant's contention for a power to place restrictions on the claimant's private life is contrary to that principle. Reference to the case of Sims, and the relevant paragraph is in the authorities bundle at page 169. Page 169 of the authorities bundle is at page 131 of the judgment, and it's at 131E to G that the relevant section appears.
Sorry, page.
Authorities bundle, page 169.
Yes.
At E.
And which was the passage in the judgment you referred to?
Yes, the passage beginning at E, parliamentary sovereignty. Parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The Human Rights Act 1998 will not detract from this power. The constraints upon its exercise by Parliament are ultimately political, not legal. But the principle of legality means that Parliament must squarely confront what it is doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts, therefore, presume that even the most general words were intended to be subject to the basic rights of the individual. And so, where fundamental rights cannot be ridden by general or ambiguous words, in the absence of express language, of clarity or necessary implication to the contrary, in my submission, the sort of power being contended for here, an extraordinary one to impose restrictions on the private life of police officers affecting their families, no right of appeal, with no recourse to the Secretary of State, that would have to be provided for in clear language, and that plainly is not the position. And so the difficult wording of Regulation 6.2, the infelicitous drafting, the lack of clarity itself, in my submission is a reason not to read it as conferring such a power. At best, it is unclear, and therefore no such construction should be imposed. And our submission is that the principle of legality points against reading in such novel and fundamental powers. The next point in support is made at paragraph 40 of the skeleton. We submit that there's no mention of the Independent Office of Police Conduct in the regulations. The IOPC don't appear in Regulation 6, which gives of an operational anomaly on the construction that's been offered. The IOPC, the court will know, is the regulatory body established by the Police Reform Act in 2002 that ensures and is ultimately responsible for effective discipline function in all police services. And the IOPC can investigate cases, indeed the most serious discipline cases and those of the greatest public interest are investigated by the IOPC, including ones where the criminal allegations arise. That is generally reserved for cases of the greatest public interest and seriousness. And there is also provision under the current regulations for the Director General of the IOPC to conduct the discipline hearings themselves in terms of presenting them before the independent panel. And the absence of any provision for mention of the IOPC within the provisions that are relied upon to define this power, we submit, tends against interpreting Regulation 6 as intending to confer a power in support of discipline proceedings or investigations, because the principle, or at least the final arbiter of police discipline, the IOPC, is not included within it. And that is anomalous if one looks at the position as to their role in restrictions that can be imposed. So we're back in Regulation 11, please, in the supplementary bundle at page 71. Regulation 11 begins at page 69, but towards the end of Regulation 11, subparagraph, sorry, I beg your pardon, page 70, not 71. No, I do mean 71, I'm so sorry. Regulation 1111, page 71, supplementary bundle. This is where suspension or restrictions in the alternative, suspension is being considered. In a case to which paragraph 18 or 19 of Schedule 3 to the 2002 Act, directed independent investigations apply. Just pausing there, that's what's been described by the High Court as the labyrinthine provisions of Schedule 3 are those provisions that determine when the IOPC has conduct of cases. So in an IOPC case, the appropriate authority, that's the force, must consult with the Director General in deciding whether or not to suspend the officer concerned under this regulation, and in deciding, following a review, whether or not to end a suspension under this regulation. And so there is provision where decisions are being made as to what restrictions or suspensions are placed upon the officer for reference to the IOPC, but on the current construction of Regulation 6, but they're not mentioned in there, no requirement to consult the IOPC where the restriction extends into private life. So if one remembers those 5 restrictions in which I said that the middle one, restriction 3, was conspicuous, the regulatory regime, as interpreted by the respondent, would give of the anomaly that one of those restrictions would not need to go to the IOPC, but other decisions would. And so the lack of mention of the IOPC in Regulation 6, especially when they are mentioned in Regulation 11, tends against construing the power to be that which is contended for. There's also, staying within the regulations, I'm moving on to the next point within the skeleton, but can be made shortly. Page 70 of the supplementary bundle, still in Regulation 11, there is a requirement for the appropriate authority to review suspension conditions. And it gives some detail of the times at which that must be done. And so restrictions on duties, the suspension decisions made pursuant to discipline aims must be reviewed. But on the current position as established in the judgment below, more fundamental restrictions to the same ends need not be reviewed because they're not within Regulation 11.8. And there's nothing within Regulation 6 to require a review. So we have the anomalous position of Regulation 3, the most severe and intrusive of the restrictions, being the only one that there's no requirement upon the appropriate authority to review at any time.
Sorry, Regulation 3, the most severe restriction. Sorry.
Sorry, Restriction 3.
Restriction 3.
Did I say regulation?
Yes. Yes.
Restriction 3, the most severe of the measures, is the one that doesn't need to be referred, or it doesn't need to be reviewed by the appropriate authority, nor referred to the IPC, as I've already said. None of these anomalies arise upon the appellant's construction of Regulation 6. Which brings me to my last point on the functions issue, made at paragraph 42 of the skeleton argument. This is the distinction, this is whether participation as an accused is exercising a police function. We say there's a difference between functions and duties. The only authorities on the issues of the meaning of a police function arise in the context of assaults against police officers in circumstances, the cases that I'll turn to briefly. There are cases where police officers have hands on a member of the public, a subject person, when not arresting them, or when it is unlawful for some reason. The courts have been called upon to decide whether the violent resistance to that restraint or that touching is an assault against an emergency worker in the exercise of their functions. And so the cases address the meaning of police functions and the difference between that and duties, there being two offences that could be charged. Assault of execution of an officer in the execution of his duty is one. Assault of an emergency worker in exercise of their functions is another. The cases address whether the same test applies to both. But the first of those is the judgment of Lord Justice Popplewell in Campbell and CPS. The context, the factual context is that which I've just described generally, and it's the authorities bundle at page 212 that identifies the issue. Page 212 of the authorities bundle, at the beginning of the Campbell and CPS judgment, it identified in paragraph 1 a conviction of assault of emergency worker under section 39 of the CJA 1988, and section 1 of the Assaults on Emergency Workers Offences Act 2018, that's the 2018 Act. Addressing the question of whether paragraph 2, whether a police constable must be acting lawfully in order to be in exercise of functions. At paragraph 7, that's about 2 pages further on, the issue is, the arguments are identified. Page 214, authorities bundle, paragraph 7. The appellant submitted to the justices that the test as to whether a police constable was acting in exercise of functions as a constable for the purposes of the 2018 Act was the same as whether a constable was acting in execution of duty for the purposes of the offence in section 89(1) of the Police Act 1996, assaulting a constable in execution of duty, summarising what I've just said. And the reliance that I place upon this judgment is at paragraph 17, which is at page 218 in the bundle, where the learned judge gives the answer. Paragraph, it's the second line I'm interested in, but reading from the first. First, the language of section 1.1 of the 2018 Act makes no reference to duty or lawfulness, but only to carrying out functions. Function is a word which connotes an activity and a role in which the activity is undertaken. Duty, on the other hand, is a word connoting responsibility or obligation. This is a passage that we'll see in a moment is cited with approval in the case of Ahmed, but sets out the difference between function and duty, making a difference to criminal liability, and it so happens in this case. Just before I move on to Ahmed, can I just ask paragraph 22 to be noted? That's at page 220. A concern was raised that there would be adverse results if that construction was given. It's the last 3 lines of paragraph 22 that echoes what I've said about the standards of professional behaviour in this case. Moreover, the last 3 lines of 22, there are many incentives to encourage police officers to abide by their statutory and professional responsibilities in relation to search, seizure, arrest and detention, irrespective of this legislation, which I submit is echoing what I've said about things already being covered elsewhere. The second authority, Ahmed, that I mentioned, is the relevant passage is at page 190 of the bundle. This is a case addressing a similar issue on when a constable is exercising functions as opposed to when they are exercising in the course of their duty. Page 190, paragraph 19. The case I just referred to in Campbell, 2020 WHC 3868 added. The Divisional Court held that the expression in exercise of functions in section 1 of the 2018 Act is not to be construed in the same way as the expression in the execution of his duty in section 89.1 of the 96 Act, and reports no requirement that the emergency worker be acting lawfully. See in particular paragraphs 17 to 21, where Lord Justice Popplewell identifies the 5 reasons for the conclusion. So that's the paragraph 17 that I had just mentioned. And I also ask, turn forward within this judgment to page 193 in the bundle. Paragraph 25, Roman 4. But there's a within the skeleton argument. There's an error in the skeleton argument. It talks about paragraph 71. That was a reference to where this appears in the judgment of Mrs. Justice Lang. It's paragraph 25.4 of the judgment that I'm interested in. When considering the broad functions of a constable, and although arising in a different context, some assistance can be obtained from the discussion of police purposes in the Crown Centre for Advice of Individual Rights in Europe and the Secretary of State for the Home Department, was the reference. As explained in that case, the purpose of police service is to uphold the law fairly and firmly, to prevent crime, to pursue and bring to justice those who break the law, to keep the Queen's peace, to protect, help and reassure the community, and to be seen to do all this with integrity, common sense and sound judgments. And so the conclusion at 26.2, where the Magistrates' Court correct to find functions of a police officer means duties, answer no. So we submit that misbehaving is not a function of a police officer, nor is participation, abstaining from misbehaviour. And while there may be responsibilities engaged in this case regards the officer not reverting to a disciplinary case, it's not a function.
I'm missing something. I mean, it's not a duty either. These 2 cases seem to me there is very long-standing authority, that certainly was when I used to practice in magistrates' courts, that police officer in the execution of his duty means in the lawful execution of his duty. And the question under this much more recent statute, 2018 Act, referring to emergency workers, is the different word functions is used. And the Divisional Court seems to me to have held in both cases that there isn't the same overlay, the requirement that they must be acting lawfully. But no doubt that's right, but why does it help us? It's neither the duty of an officer nor the function of an officer to misbehave.
Yes, I agree. I can see there's a responsibility on an officer not to misbehave because they're subject to that under the standards of professional behaviour. But provided, unless there is a function identified for the accused in a discipline proceedings, then we're not within regulation 6.2, the first part of 6.2. That's the point. I submit that I succeed in my submissions if it's not a function. If it's not a duty either, then it's an even stronger argument. But provided it's not a function, it's not within 6.2. It was found in this judgment that it was a function, subject to what I'm about to say.
Right.
So the paragraph 75, as I've just read them up to determination 4. There are 4 reasons we submit at skeleton paragraph 45 why disciplinary proceedings do not invest functions in the officer as found, as they would need to come within 6.2. The first is that the accused officer has no functions within his own discipline case. If one identifies what the functions in a discipline investigation are, they would include obtaining accounts, identifying the accused, gathering evidence, appointing decision makers, determining case to answer, giving all the many notices and requirements that are provided for in the regulations. But those are the functions, appointing a chair and a panel to convene any hearing. Those are the functions in a discipline investigation. The accused officer isn't discharging a function being made subject to one. Not least because, I'll point to it, paragraph 46 of the skeleton, an officer is a party, can't be impartial. One would imagine that police functions need to be discharged impartially. An officer must be impartial in discharge of functions, but cannot be impartial in his own discipline case, as they are adversarial in nature, with the right to be represented by lawyers in serious cases, and so on and so forth. This is not in our submission discharge of a function. There's also a problem in our submission with paragraph 75 in that the judgment does not identify what the police functions are. Now, in paragraph 47 of the skeleton argument, it's suggested that the administrative court didn't find the appellant had any functions at all. I withdraw that. That's in error, because if one looks at the claim bundle, page 79 at paragraph 75, in the last part of that paragraph, restriction 3 was designed to ensure the claimant exercised his functions properly within the disciplinary proceedings and did not jeopardise them by interfering with the complaint. So it was in fact found that the claimant, the appellant, did have functions in his own discipline case, but not what those functions were. But it seems that those functions are not refraining from interfering because of the word them. Exercised his functions properly and did not jeopardise them by interfering. So the interference isn't the function, it's something else. But we know not what. And our submission is no anomaly on the appellant's construction, there are no functions, which takes us outside regulation 6. We also observe in a thought experiment that is helpful that the fact that an officer doesn't have functions in their own discipline case is demonstrated by the possibility of resignation. If an officer resigns, the police conduct regulations still reach the former officer. I perhaps won't turn it up, but the references for that, if of interest, are in the Home Office guidance. Supplementary bundle, page 176. It describes what I can summarise at paragraphs 5.36 and 5.39, the reach of the regulations to former officers. It's not considered any less important to bring serious discipline proceedings, especially regards matters that might lead to dismissal against former officers, because that's the only way in which they can be placed on the barred list that prevents them coming back or applying to another force. But where an officer resigns, they are still a party of the discipline proceedings. They still provide responses, they are still represented, they can give evidence, make submissions, and play their part in responding to allegations that are made. Resignation results in all police functions ending. That must be uncontroversial. Yet the discipline case can continue. So participation in discipline proceedings as an accused can't be fulfilling a police function, because you still participate as an accused after resignation when functions have ceased. There's that point's poorly expressed at the end of paragraph 48 of the skeleton. What it's trying to say is this: that resignation results in all police functions ending, yet discipline can continue. So participation in discipline proceedings as an accused is not fulfilling a police function. That's why there's no anomaly on the appellant's construction, that participating in discipline proceedings as an accused is not fulfilling functions. Determination 5, again in judgment paragraph 75, we submit it's found that restriction 3 is designed to ensure the appellant exercise those functions properly within the disciplinary proceedings. We submit at paragraph 49 that this restriction goes beyond policing functions in the discipline case. If the function were not to interfere, which is as close as one can get to identifying what it might be, my submission, then this prohibition restricts all contact. It restricts innocent contact, mutual reconciliation outside the discipline sphere with their family. It restricts contact that doesn't touch upon, jeopardise, or seek to jeopardise discipline at all. And so it goes too far. The standards of professional behaviour, a point that we addressed at the beginning of the day, the standards of professional behaviour prohibit any behaviour that lacks integrity or is damaging to police confidence or police reputation. And restriction 3 so it does no more than seek to rehearse. Well, it does more than seek to prevent such contact. What the restriction adds is to render innocent contact a professional breach. A text that said, "Can I see the children?" replying to a text which said, "Come quick, there's an emergency concerning one of the children." This restriction renders replying to that text professional discipline. The standards of professional behaviour don't prevent him doing that. The standards of professional behaviour are limited to matters which are discreditable or lack integrity. But if that were a lawful order, replying to that text would be a breach of discipline. So what this restriction does is extend the prohibition that's already upon him in the standards of professional behaviour, only capturing the innocent contact. That's the only extra bit, that's the only function, the only extra thing it does on top of what the standards of professional behaviour already do. And we submit at paragraph 52 that all policing control can be managed under the regulations in the way that those other restrictions do, taking him away from cases and meeting those public concerns. Well, those are my submissions on ground 2. I appreciate I'm taking a little while. I hope to be able to complete these submissions. May I turn to ground 3?
Yes, indeed.
Ground 3 concerns section 4.3 of the Police Reform and Social Responsibility Act, or PRSRA, and the supplementary bundle at page 195 is where that provision is found.
It's right, isn't it, that this happens with the section that deals with the Commissioner of the Met, but there's an exactly equivalent section for every other Chief Constable.
The first thing yes, my Lord, the first thing I was going to say is that the section 2.3 of this same Act provides the same for chiefs of other forces. The Act is described as an Act to make provision about the administration and governance of police forces. And whatever your Lordship and Ladyship's judgment may be, it will, in my submission, hold good for all forces, not just the MPS. And it may be that we should provide section 2.3 if your Lord and Ladyship's wished to make that clear in your judgment. But your conclusions will apply to all chiefs and not just the Commissioner. So determination 6 is that, well, one looks at 4.3 first, just to remind ourselves of it. The Metropolitan Police Force and the civilian staff of the Metropolitan Police Force are under the direction and control of the Commissioner of the Metropolis. Now, the finding within the judgment at core bundle page 80 is at paragraph 81. Sorry, page 80.
Yes.
Yes, page 80, paragraph 81, conclusions. I accept the defendant's submission that the imposition of restrictions on officers during misconduct proceedings falls within the defendant's responsibility for the direction and control of the Metropolitan Police Service as set out in section 4.3. And should be read together with a specific provision for chief officer to impose restrictions on private lives in paragraph 2 of schedule 6. And if one stays on the same page and looks at paragraph 78, that same page, there's reference to the policing protocol issued pursuant to section 79, assists with the interpretation of direction and control. Two sections there. Chief Constable has direction and control over officers. And 22, the Chief Constable is accountable to the PCC for the delivery of efficient and effective policing. That's said to support the finding that the powers within regulation section 4.3, we submit there are 5 reasons why direction and control under 4.3 does not extend to individual officers. They're at paragraph 54 of the skeleton, and they begin, importantly, with what we submit as a very helpful case of North Yorkshire Police Authority. So the authorities bundle at page 99 assists with where the dividing line is, as to how far section 4.3 reaches. So beginning at page 99, North Yorkshire Police case is a complaint about a care provided to a resident who died at a home. The investigation had concluded there was no criminal offences, and the Chief Constable declined when asked personally to investigate that conclusion that there were no criminal offences. And so the complaint was about the Chief Constable's response. And the issue in the case is whether there was an obligation to record complaints about the Chief Officer's direction and control of police forces, because the police authority had refused to record the complaint because they said it was a direction and control matters. So in that context, the court was considering the meaning and remit of direction and control, and in my submission, addressing directly the question of whether direction and control extends to granular detail or individual decisions or something else. At page 109 of the bundle, one finds paragraphs 38 and 39. This is the conclusion. I'm going to illustrate how it's reached and then apply our case to it in a moment. But at the very end of 38, just the last couple of lines, one picks up the decision they were considering. The issue's direction and control matter as it related to the deployment of resources, to his decision not to deploy men to investigate a complaint that had already been investigated by other agencies. And then this at 39. I would not accept this analysis. It's not easy to produce a comprehensive yet accurate definition of the concept of direction and control. I think, however, that it is essentially concerned with matters which are of a general nature. On this basis, a decision by a chief officer which is confined to a particular subject falls outside the scope of direction and control. The national and local guidance from which I have quoted at some length earlier in this judgment appears to me to be fully supportive of a general particular dividing line. This is a paragraph in due course I'm going to invite the court to approve of, but may I just pause to explain how it is reached and demonstrate the same applies in our case. So the learned judge refers to national and local guidance. If we go back to page 103 of the judgment and find paragraph 17.
103 of...
Sorry, page 103 of the bundle, paragraph 17 of the judgment. In March 2005, the Secretary of State issued guidance on the handling of complaints relating to the direction and control of a police force by a chief officer. And then in the paragraph that is produced below that, one can see direction and control of a police force and gives a description. And then there are a number of bullet points as to what it means, operational policies, organisational decisions, general policing standards, operational management decisions. So that was some of the underlying material which led His Honour Judge Langan to reach the conclusion at paragraph 39. And the respondent's submissions in our case is that Regulation 4.3 is of a general, does apply on a general and higher level, but also to the granular detail of individual officers. If one looks for the equivalent underlying material in our case to that which appears at paragraph 17, that is the policing protocol. And the relevant passage, part of which is already seen cited in the judgment, is in this supplementary bundle. Supplementary bundle, please, page 200. Two relevant paragraphs. The first is that which we read in, this is Justice Lang's judgment just now, paragraph 22. The Chief Constable is accountable to the law for the exercise of police powers.
So sorry, I'm behind you again. The protocol is supplementary.
Supplementary bundle, page 200.
Yes.
Paragraph 22, as reproduced in the judgment below, the Chief Constable is accountable to the law for the exercise of police powers and to the PCC for the delivery of efficient and effective policing, management of resources and expenditure by the police force. Let me say that's consistent with general control. But more instructive still is 2 pages forward at page 202 of supplementary bundle, paragraph 33. This, in my submission, is the equivalent paragraph to that which we saw in the North Yorkshire Police case just now at paragraph 17. The direction and control of a Chief Constable will include the ability to issue a warrant to an attested officer with which the officer may exercise police powers, decisions in relation to the appointment and dismissal of officers and staff, decisions concerning the configuration and organisation of policing resources, or the decision whether or whether not to deploy police officers and staff, total discretion to require investigation into crimes and individuals he or she sees fit, decisions taken with the purpose of balancing competing operational needs within the framework of priorities and objectives set by the PCC, operational decisions to reallocate resource to meet immediate demand, and the allocation of officers' specific duties and responsibilities within the force area to meet the strategic objectives set by the PCC. Granted, that we see from the next paragraph is exhaustive, but illustration only. But what it illustrates in my submission is exactly that which was spoken to in the North Yorkshire Police case at paragraph 39, namely that direction and control is essentially concerned with matters of a general nature. So decisions like this fall outside direction and control, and that this material is fully supportive of a general/particular dividing line. And so, as I have mentioned, I invite the court to approve paragraph 39, if it's on Judge Langham QC's judgment in North Yorkshire Police case, and conclude that it tends against a finding that section 4.3 bestows a power of such immense individual particularity as imposed in the present case. And I just pause to remind the court of Glazer. Remember, I submitted there needs to be procedural mechanisms by which individual members of the family could have an input on the decision. If this is a direction and control matter, it is curious that there's a requirement on the Chief Constable of Police to receive representations and to take into account the views of individuals, individual members of the public. And so the section 4.3 and the Article 8 points do not align. Again, a theme which I impress upon the court. None of these anomalies appear on the appellant's construction of these provisions. The next point in the skeleton is that the policing protocol assists but points the other way. That's the point I've just made. And as to the finding of the learned judge that one power supports the other, may I just invite scrutiny of potential circularity within the judgment. So we begin at paragraph 57 of the skeleton, but within the claim bundle at page 77, we find ourselves back in Mrs. Justice Lang's judgment. It's paragraph 70, is the first of two that I refer to. So the second half of that 70, as I've mentioned, is cited in support of Regulation 6. In my view, it confirms that the broad powers the defendant has to direct and control police officers in the PR, it confirms the broad powers which the defendant has to direct and control police officers in the Metropolitan Police Service, currently set out in the PR SRA, may include the imposition of restrictions on an officer's private life, provided designed to secure the proper exercise of the functions of a constable. So there it appears to be being said that Regulation 6 confirms the powers found in 4.3 to impose the restriction. But if one turns forward to page 80 in paragraph 81, there the Lone Judge says, I accept the defendant's submission that the imposition of restrictions on officers during misconduct proceedings falls within the defendant's responsibility for the direction and control of the Metropolitan Police Service, as set out within section 4.3 PR SRA 2011, and should be read together with the specific provision for chief officers to impose restrictions on private life of officers in paragraph 2 of Regulation 6 of the regulations. So there appears to be a finding that here that Regulation 6 provides the power, but also that Regulation 6 confirms the power is in section 4.3. Perhaps not entirely clear whether power has been found to exist in both. It reads more or less that it has. But if then one looks at paragraph 83 of the judgment, it says it's common ground that restriction 3 engages Article 8 ECHR. However, Article 8 is a qualified right which can be overridden, see ground 4 below. In any view, Regulation 6 of the 2006 regulations permits the defendant to impose restrictions on private life, including restriction 3, in exercise of his general power to direct and control police officers under 4.3, which may read as though it's section 4.3 that informs Regulation 6, and in fact the imposition of the restriction is under Regulation 6. We submit that there is a circularity and a lack of clarity as to where this power has been found to apply and to why. But in any event, the Allard cases I've mentioned and the New York police case draws a dividing line that pushes it outside Regulation 4.3, Section 4. Neither of these provisions, of course, makes any reference to the other, one emanating from 1948 and taken forward. In further support, we adopt submissions we made earlier, paragraphs 58 and 59 of the skeleton. No equivalent power for the IOPC, as is contended for section 4.3. That's the same point I've made under Regulation 6. And we reiterate that misconduct powers are found in conduct regulations, and this power does not appear there. Determination number 7 is found within paragraph 82 of the judgment. My Lord may have open.
Yes.
I do not accept the claimant's submission that this analysis offends against the principle of legality, and that's set out faithfully there. The reasons given for that are in paragraph 83. It doesn't offend because Article 8 is a qualified right. That's number 1. And number 2, because Regulation 6 allows it. In response to those two findings in relation to why the principle of legality is not offended, I refer to paragraph 62 of the skeleton argument. Shortly, the fact that it's a qualified right does not mean that it is a fundamental right. Therefore, it's still subject to the principle of legality, and one would still need clear and express, unambiguous language to construe such a power. And second, the support that's provided on the basis that Regulation 6 provides it, well, those are my submissions generally in the context of this case. Well, that brings me to ground 4 that I hope I can deal with in a few minutes in time for the natural break.
Yes.
Ground 4 refers to Article 8, and in the judgment of Mrs. Justice Lang, this appears at paragraph 98 in terms of the finding itself, a declaration that it was a proportionate interference.
Yes.
I repeat and adopt what I said about the Article 8 jurisprudence in cases. And we submit that the relative weight that has been attached as between potential police misconduct proceedings and family life in this case is miscalibrated, and there's an underestimation of the importance of family life and the weight to be attached to it. As I say, I adopt those references that I took the court to under the Article 8 authorities in my submission, that family life weighs very heavily and that interference should not be light and must be kept to a minimum. Here, when we are concerned with what was a potential witness in a potential discipline case that since has graduated to an actual discipline case. And comparing the example of Rukin that I've been through, we submit this as an unjustified interference. We say it goes too far because it prohibits all contact, including innocent contact. That's a point I've already made in another context already. And that it has no limit of time, albeit it is temporary. It has persisted for months or years already, and inhibits contact with children, which has to be via a third party. There is another problem with the judgment.
Are you saying that that's the only reason the contract is via a third party?
I'm sorry, my lady.
Are you saying that's the only reason contact with the children is via a third party, the existence of this direction.
The
It's nothing to do with the family court.
I need to take instructions on that.
No. All right. Well,
May I do
perhaps
that?
it doesn't matter, but seemed it was quite a. It may well be that there
You
are
might be
other
right.
reasons why that is happening.
Yes, I accept that. Nevertheless, the point in principle is that this power would be available irrespective of there being any family proceedings at all in circumstances where the family isn't disjointed or hasn't fallen out, because the rationale is about the discipline proceedings rather than anything else. There's something else to the judgment, though, that conflicts with what's gone before, and that's at paragraph 94 of the judgment, at page 82 of the bundle, on the question of proportionality under Article 8. The learned judge said, I go on to consider proportionality as this affects the question of relief. I accept that the defendant could impose restriction 3 in pursuant of the legitimate aims of prevention of disorder or crime and the protection of the rights and freedoms of others. Well, that's of course a different reason for the imposition of the restriction to that which is present in this case. There is no suggestion by the respondent that this condition was imposed for the protection, in law for the protection of the witness, but rather for the protection of the integrity of the discipline proceedings with regards to contact with witnesses. And in this guise, it resembles even more a bail condition in criminal proceedings. We impress upon the court that the inability to impose such a restriction, the disproportionate nature of this restriction, gives of no adverse or anomalous results regards the interests of third parties or individuals that might be at risk of harm from police officers that may pose a risk to others. And in that, we submit that paragraph 96 of the judgment on that same page, that the finding that non-molestation orders are not preventative in nature is in error. They are so preventative.
I think you're right about that, speaking for myself.
I'm grateful. There is within the bundle some supplementary bundle, some of the relevant extracts, but I perhaps needn't turn them up. The essence of our submission is that a non-molestation order is an injunction. That's supplementary bundle 211. It says it prevents things. That it can be general or specific under page 212, and there's guidance on what an association is within the form at 222. So non-molestation orders are available for associated persons.
I wonder whether the judge might have left out the word unlike at the beginning of 96. Disciplinary and criminal proceedings are not preventative in nature, but non-molestation orders are. Anyway, perhaps it's not a very important point.
Maybe, my lord. The legal definition of molestation is very wide. Again, given the time, I won't turn it up, but the reference is at page 112 of the authorities bundle. That's why the case of Johnson and Walton is in there, and it is it's a very low bar in order to meet the definition for molestation. And similarly, in the case of Vaughan, the relevant extract for the court's note is at the authorities bundle, page 120, extremely low bar to qualify as molestation, and so there is ample provision within that law for the protection of individuals that might need it. And for those persons that are not associated within the meaning of the non-molestation legislation, the provision that prohibits harassment of another, that provides protection for them, that's section 1.1 of the Protection from Harassment Act at the supplementary bundle, page 236. It too has an extremely wide definition, given at section 7.2, supplementary bundle, page 242. And there are remedies including injunctions against potential harassment, which can mean no more than just turn up 242. References to harassing a person include alarming the person or causing the person distress. So any distress can be prevented by an injunction. The provisions for that under 238. That's even for apprehended breaches. And so there is, in terms, if the rationale were protection of another, there's no anomaly by the absence of the power of the chief to prevent an officer contacting someone. It's amply covered elsewhere in all of that legislation. My Lord and Ladies, those are my submissions.
Thank you very much indeed. 2:05.
All rise. Sorry, sir. Sorry.
Sorry.